Program Fakulty of Law, Universitas Islam Indonesia. Dear the participants, welcome to the public lecturers visiting Professor Chot in Law, Administrative Law, the Dutch perspective held by Magister and Doctoral Faculty of Law, Universitas Islam Indonesia. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning. The Honorable Professor Arbechan Toleners, Professor of Empirical Legal Studies and Local Governance, Faculty of Law, University of Groningen, Netherlands. The Honorable Professor Dr. Budi Agus Ariswandi, SH, MHum, as the Dean of Faculty of Law, Universitas Islam Indonesia. The Honorable Associate Professor Dr. Andes Agus Trianta, MA, MH, PhD, as the Vice Dean of Student, Religion, and Alumni and Network Affairs, Faculty of Law, Universitas Islam Indonesia. The Honorable Professor Dr. Sefriani, SH, MHum, as the Head of Master Program in Law, Faculty of Law, Universitas Islam Indonesia. The Honorable Dr. Idurisan, SH, LM, as a Secretary, Magister, and Doctoral Program, Faculty of Law, Universitas Islam Indonesia. The Honorable, the lecturers in Faculty of Law, Universitas Islam Indonesia, and also all the participants we are proud of. Before beginning my speaking, let us thank you Allah who has given us rahmat and hidayah, also blessing and mercy, so we could meet together in this occasion with healthy and very happy. Salawat and salam to our beloved Prophet Muhammad Sallallahu Alaihi Wasallam, who has bring us from the darkness time to the likeness time, from the bad character to the good characters. Ladies and gentlemen, in this nice occasion, let me as a master of ceremony deliver the structures of the agenda for today as follows. The first agenda is opening. The next is opening speech from the Dean Faculty of Law, Universitas Islam Indonesia. The next one is introduction to the lecturer and the discussion topic by the facilitator. The first agenda is public lectures on child law in administrative law, the Dutch perspective. The next agenda is the question and answer sessions, followed by reward session, and the last one is closing. Ladies and gentlemen, before we come to the main sessions, let's open this agenda by prayer based on the individual belief. Pray, begin. Done. Ladies and gentlemen, the second agenda is opening speech from the Dean Faculty of Law, Universitas Islam Indonesia, to Professor Dr. Budi Agus Ariswandi, SH, MHum. The floor is yours.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning. The Honorable Professor Arbechan Toleners as speaker. The Honorable and all the participants we are proud of. Before beginning my speaking, let's have thanks to Allah who has given us rahmat and hidayah, also of his blessing and mercy, so we can come together in this agenda with healthy and very happy. Salawat and salam also greet and pray to our beloved Prophet Muhammad Sallallahu Alaihi Wasallam, who had brought us from the darkness time to the lightness time, to the bad character to the good character. Ladies and gentlemen, today we will have public lecture concerning tort law in administrative law, the Dutch perspective, with Professor Albertson from Faculty of Law, Groningen University, Netherlands. This topic is very interesting to us. Why? Because if we know this topic, we will get 3 points, namely, the first one, we get to know what is tort law in the Dutch administrative law. For example, in concept, empirical, and its regulation. And the second one, we can compare this concept and regulation between tort law in the Dutch administrative law and Indonesian administrative law. And the last one, we can find plus and minus between both. Ladies and gentlemen, so I hope all of participants can be joining and be active to discuss this topic. I believe Professor Albertson is expert in this area, especially in the Dutch administrative law. Finally, thank you, Professor Albertson, as speaker and all of participants. Enjoy your presentation and let mix productive discussion. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you, Professor Dr. Budi Agus Triswandi SH MHum, as the opening speech given for us. Ladies and gentlemen, we come to the next agenda is introduction to the lecturer and the discussion topic by the facilitator, Mrs. Rahama Madatila, and also followed by the main agenda public lectures on the tort law in administrative law, the Dutch perspective. And then to the Mrs. Siti Rahama Madatila SH MH, the floor is yours.
Good morning, ladies and gentlemen, to the Honorable Professor Budi Agus Triswandi SH MHum, the Dean of the Faculty of Law, University of Islam Indonesia, and the Honorable the Vice Dean of the Religion, Students, and Alumni Affairs, Dr. Andes Agus Trianta SH MA PhD, and to the Honorable the Head of Professor Sefriani SH MHum, the Head of the Master of Law Study Program at this Faculty of Law, Universitas Islam Indonesia. And very well welcome to the all participants, lecturers, and also the students from the master and doctoral program. And today we are going to discuss about the very interesting topic about the tort law in administrative law from the Dutch perspective. And before we get into our main session, I would like to introduce you to our main speaker and our special guest today, Professor Albertson Tolenaar. He come from the far away. He come from far away from the Netherlands to see you all here in this session. And before we get into to the discussion and to the lecture, I would like to introduce you about the short CV, curriculum vitae, and profile about the Professor Albertson Tolenaar. Professor Albertson Tolenaar is the professor of empirical legal studies and local governance at the Department of Constitutional Law, Administrative Law, and Public Administration from the Faculty of Law, University of Groningen, the Netherlands. And he started his career as a PhD student at the Faculty of Law, the University of Groningen, with the dissertation titled Municipality Policy and Policy Rules. After that, he did his postdoctoral research in the project of safeguarding public interest in the private sector social security at the Max Planck Institute for Social Recht and Social Politik Munich, Germany. Besides being a professor, he also served as the director of the Groningen Graduate School of Law. And outside of academic activities, Professor Albert-Jan Tolenaar is a member of the advisory committees for objections in the municipalities of Groningen and Het Hoogland and Burgerorden. Pardon me if I have a wrong spelling, Professor. Well, without going further ado, Professor Albert-Jan Tolenaar, I invite you to join me here at the stage. Yeah.
Should I sit or stand?
It's up to you.
I prefer to stand because it's more active.
Okay,
right?
okay.
But then the camera cannot see me. That's the funny
Okay.
thing.
Maybe I need to inform you that the time is 1 hour.
Okay, yeah. Great. Okay, thank you so much for having me here. My name is Albert-Jan Tolenaar indeed. I'm a professor of local law and governance. And it actually means that I'm interested in what the law looks like, but also on how people behave within the law. And my main focus point is then municipalities, so the local governments. And to give you an idea, local governments in the Netherlands is rather small. I mean, the average number of inhabitants of a municipality is about 50,000, but it's relatively small compared to Indonesia, right? I will give you a short lecture on government liability and damages as a remedy, and to give you some insights on the debates that are happening in the Netherlands, since I think some of these debates are very familiar to you as well. There is always a struggle between the question who is in the end the institution that keeps the government responsible, accountable, so to say. Well, there are many ways to hold the government accountable, and one of it can be using tort law. I will just ask you sometimes to click, so now you can click. Click, next one. Next, yes, thank you. The big question is, what happens if the government causes damages? That is my main focus point for today. And yes, thank you. Next one. We will, in the end, we will have a very fluent collaboration. If you just click again. Yes, thank you. And I give you just 4 recent Dutch examples where you see that the government causes damages, causes damages. And the question is, what happens now? How can we as citizens hold the government responsible for that? And how can we perhaps get some kind of compensation for it? These are 4 examples, and I go clockwise. So here we see a big crack in the wall. This is caused by mining, by earthquakes, I have to say, by earthquakes. And these are earthquakes, not the earthquakes that you are familiar with. These are earthquakes caused by mining. And this is especially in the area where I live, Groningen. Sometimes the earth is moving. What happens there is they are mining. That means they are extracting gas. And if you extract something, one thing is for sure, that the soil will move, right? And that is happening now. And sometimes it goes fast, and then you have an earthquake. And these earthquakes are not very severe for your standards, but for our standards it is, and cause damages. You can see here damages. Your house is more or less demolished. Over there we see, this is just a picture of pollution. We had a big case. It's called Urgenda, that was about carbon dioxide emissions. And the question was, well, does the government enough to prevent us from climate change? And so there is some kind of damages popping up, happening. And the question is, can we hold the government accountable to do something against it? Then we have this one. It's in Dutch, what you see here, but it says, the horeca needs to be, that the cafes need to be open, otherwise we will be gone. That is the reaction, a demonstration. You can see, perhaps you don't find this interesting, but or not very serious, but we had big demonstrations after the lockdowns due to COVID. And I think you had similar measures here as well in COVID. In COVID times, the government made decisions for severe lockdown, meaning that all public institutions and also cafes had to be closed. And there was one thing for sure: if you close a cafe, the cafe owner cannot earn any money. Yeah, thanks to GoCheck and other ways you can make some money, but it's less. And many of the cafes were then demonstrating and wanted to know to get some compensations because of this. And this is the other one. It's all in Dutch, so that's a pity. But that's a case. It's the child benefit case, and that is what happened. We still have, by the way, a child benefit system. That means that if you have a kid and you send them to daycare, you will get some compensation from the government, some kind of benefit. But the system is, on the one hand, very simple, and on the other hand, rather complex. What is simple is that you will get something, but what is complex is that what you get is determined on the projected income that you will have. So that means you have to assess in advance how much money will I earn this year. You have to say that to the tax office, and then the tax office will then, based on that calculation, assessment, it will give you a benefit. But if you happen to have to earn more money, lucky you, but then you have to repay. And if you did not send your kid to the daycare for the amount of hours that you were supposed to do, you will have to repay as well. And what happened is that the tax office did some scrutiny of certain files, and especially with people with a certain family name, with a Moroccan or a Turkish background, they were scrutinized a little bit more. They were seen as potential fraud committers, and therefore, had to repay. And these repayments, don't underestimate it, it was 40,000 euros, and these people did not have any money. So what happened is that they got in debt. They got, quite often they were kicked out of their houses. They would even, sometimes the government would take away their child. So there was big damages. And these are the people that are demonstrating against this. They were raising their voice. And just to show you how big it was, even the government, the executive power collapsed due to this. The minister had to resign. So it was a serious matter, and we are still in the phase of recovering, so to say. So these are 4 examples of people facing damages, and also, attached to some governmental action. Can you click on the next one? So you see, someone has damages. It is caused by governmental actions. And so the question is, what is actually the kind of governmental action? Is that then unlawful what the government did? And if so, if it's unlawful, is there then a need for compensation? And if yes, how? How can we get compensation? And is that then an effective remedy to hold the government accountable? So these are, let's say, legal questions. They have a legal angle in it. And I will also end with some practicalities on how the government actually behaves and how it actually works. So what kind of governmental action or act causes the damages? That's the first and foremost relevant question that you have to answer from a legal perspective. If you want to have damages, you first have to qualify the type of governmental act that is causing the problems. Can you click again? And why is that question so relevant? Well, we have a saying. It's all based on this guy. It's Ulpianus. Ulpianus is a Roman philosopher, lived 2,000 years ago. And it's always good if you can quote a Roman philosopher, right? So keep this in mind. You can always impress your family or your relatives. Jus publicum est quod ad statum rei Romanae spectat jus privatum quod ad singulum ultitatum. And actually that means there is a boundary between private and public. Public is what is there for the public interest, and private law that regards the individual interest. What is the consequence in the philosophy of Ulpianus is that there is a strict boundary between the public order and the public law and the private order and the private law. That also means that if the public, if the government does something unlawful, that in principle, there are other rules applicable than if you or I do something wrong in my capacity as a private person. If I do something wrong, I'm completely subject to the private rules, private law rules. I can have to, if I cause damages, I have to tort law applicable, etc., etc. And if the government does something wrong, in principle, there are other mechanisms to get compensation or to hold them accountable, so to say. And what we will see today is that although, but I have to add here, this idea of the strict distinction between the public order and the private order, you will see in some European jurisdictions. The best example, France. They have a very big difference between the public order and the private order. Everything that the public does is under other rules than what the private parties do, so to say. There are, there are also public enterprises, but they are subject to public rules, so it's special rules, so to say. That's a very interesting problem. This problem of the boundaries between public and private, they give rise to lots of interesting research questions. So all of you, you can think of questions, problems, I think, that are related to these boundaries. And one of these research questions relates to this issue of tort law and liability. Could you click again, please? So the causes, the question number one. So we will come up with this later on, this problem of the boundaries between the two, the public and the private order. What causes the damages? Well, there is a way to identify the type of causes, and the idea is, first of all, there are these factual acts, factual behavior. Also, the government acts factual. Like I have here an example of the garbage collection. The car drove under a port, and you can see the port was a little bit too low, or the car was a little bit too high. At least it was factual behavior, and it caused damages. This is not the most interesting or problematic one. It happens a lot that the government, in its behavior as a normal person, you could say, causes damages, and then it's just a matter of civil law applicable. Quite often there are insurance companies involved, so you will get compensation. It is also in the literature and in the research, this is not getting a lot of attention. Practical, it is interesting because indeed there are insurance companies involved, and then in essence it is rather interesting. But it is, in principle, not so difficult. What becomes more difficult, yes, thank you, is that sometimes the government, or there are ways to shift this factual behavior into something. Oh, that's my bag. Sorry, sir, that's my bag. You can leave it here. It's my bag. Yeah, thank you. Yeah, no, it's very good, very good. Sometimes you can try to link factual behavior with something that is perhaps linked to administrative behavior, administrative decisions. Like we had examples of factual behavior that were in the end linked to a decision or like a permit, or like, and then you could say you did not, you public body, you did not exercise sufficient supervision, and you should have, and therefore I can also apply not only civil law, but also administrative law, because you should have taken a decision, and therefore I can hold you also accountable on the administrative law decisions. An example that we had was perhaps a very stupid one, but okay. It was in a river. There was a boat, a ship, a big one actually, and that one was sunk. So there was a little bit less maintenance, not sufficient maintenance, etc., etc. And then, because you can imagine that if you do this in a river, the rivers in the Netherlands are like the highways for transportation. So it caused big problems for other ship owners. They could not pass, etc., etc. And what these ship owners then did, they had two different routes. First of all, they held the ship owner of the ship that went down liable for their damages. And second, they also held the government accountable, saying, you government should have taken more oversight measures on the ship owner, preventing him from having a bad ship that would sink all of a sudden, so to say. That sometimes happens, that people try to search for a public route as well, and you can imagine why. I mean, the public, the government has bigger pockets, has more money than the ship owner. Ship owner would go bankrupt, and you won't see any damages. If you can find a way to hold the government accountable as well, you would. Well, it's more likely that you will get compensation. You understand this, right? Yeah. So, factual acts quite often is, well, let's say not so difficult, but sometimes we or citizens try to find a way to search for administrative decisions that are related to these factual acts. And administrative decisions can also cause damages. Like there are many examples, like if someone receives a permit and exercises this permit, that can cause damages for a third party, or sometimes the permit has to be revoked. You already made the investments, and then there's also damages. Like suppose that our Minister for Economic Affairs gives a permit to create a nuclear plant. Well, and you got it, so you got the permit for this nuclear plant. The first thing that you do is doing lots of investments in doing researches, whatever. And suppose that later on in the procedure, there is an NGO saying, yeah, this nuclear plant might be a little bit too harmful for the environment. I just make it up, the story. And that the minister says, yeah, you're right. Or if even worse, that the administrative court says, yeah, indeed, you're right. So the decision has to be annulled or quashed or whatever. Yeah, then we have a problem. Someone has damages because of an administrative decision. And then the question arises, what then? And I will get back to that later. And the last one, that's even funnier or more interesting perhaps, that is the unlawful legislation. Even a legislator can make mistakes. The legislator can make mistakes, can issue legislation that causes damages, and that might be unlawful in the end. And that it can be, for example, there are examples in the Netherlands like legislation that discriminates, that makes an unlawful distinction between two groups. And suppose that you would go to court and the court would accept this plea, yeah, then we have a problem. Then there is unlawful legislation. And a special variance of that is the negligence, and that means sometimes the legislator doesn't do what it should do. Should impose legislation. And if you can click again, especially the last two are the most interesting, and I will get a little bit more on these two because I think these are the most interesting for this session. Yeah, can you click again? And I will refer to these 4 examples I give you to give you a little bit more insights of what actually caused the damages. The child benefit scheme, I told you a little bit about it, was actually about strict supervision and supervision based on unlawful and unclear assumptions. It was very difficult to get this into the light, but it's turned out that in the tax office, the bureaucrats were committing some kind of discrimination. They, they discriminated based on, in the end, race. So it was very a heavy accusation, so to say. And since there were very big consequences financially and socially, the government in the end admitted that it made a mistake in this very strict supervision. And yeah, but there was not so much that there was a decision involved, but mainly this factual behavior of committing too severe and unlawful discriminating supervision. And I will show you in my last sheet how they are now solving this issue. Yeah. So when is something unlawful? Question number 2. When is something unlawful? Well, for factual behavior, it's not that difficult. Unlawful is something that creates damages. It violates a rule, and this rule is also there to protect me. So that, and then, like my property rights, you are infringing my property rights, so you have to compensate me. With administrative decisions, it is a little bit more difficult. On the one hand, it can be easy. If the administrative authority admits that it made a mistake, it's easy. So suppose and admitting that you made a mistake can happen, for example, in an objection procedure. In the Netherlands, once you issue a permit or a decision, when you made a decision, there is always the option to object for third parties, but also, suppose that I deny you a permit, then you can also object against that. And that means that you give the administrative authority a second chance, a chance to rethink its decision. And suppose that in this objection procedure, the administrative authority comes to the conclusion, yeah, I was wrong. You are right. I should have issued the permit, or I did issue the permit. I shouldn't have issued the permit. If the administrative authority admits that it made a mistake, then by definition, it is unlawful. Yeah, that's an easy one. A second option would be that the administrative court would assess that the decision is unlawful. And that is already a little bit more problematic, because when does the administrative authority, administrative court come to the conclusion that it is unlawful? Yeah, the most easy option is that it assesses that the administrative authority did something that is against the specific legislation, that is beyond what is allowed, so to say. That is an easy one. Then you commit a very clear, crime would be the wrong word, but you do something that is objectively wrong, so to say. What is already more difficult is that it is if it's against soft law, policy rules, or unwritten norms, or exceeding the proportionality test. And why is that more difficult? Well, because quite often the administrative authority has some room to maneuver, some discretion, has more options that are, all these options are not seen as illegal as such, and the meaning that they are against the legislation, but well, they might be, well, not so clever, might be disproportionate, or perhaps not disproportionate, but not so very proportionate. And there you see room to maneuver, and that makes it difficult for the court to say, yeah, this decision is, although that it is not illegal as such, it's not against the legislation, but it is still unlawful. There is a difference between what is illegal and what is unlawful. If you can click again, please. And to show you a little bit more, in the end, you are testing a decision as the court. And to test a decision, you go through, yeah, you could say the different layers of testing. The easy one is the legislation. Sometimes it's also difficult because interpreting legislation also requires quite some effort, right? So, but let's assume that it is easy to observe whether or not a decision is against the legislation. Then the next step would be, is it within the legislation? Is it then against soft law? Are there own policy rules or rules from expert organizations that say, yeah, this decision, this power should be used in this direction? That is then soft law. And suppose that is still within the soft law, then still there can be formal or substantive principles that guide you in a way, you as an administrative body. And if you still adhere to these, then you have the substantive principles like discrimination and proportionality. And if you click again, and what you will then often see is that the legislation gives boundaries, the red lines here, and within these boundaries there are multiple options that are all seen as not unlawful. The double denial, we lawyers like this, not unlawful. Meaning, but yeah, you and I, and perhaps also from a political perspective, can already see that this would be a better solution than that one. Yeah, but yeah, since it is up to the administrative authority to make the decision, to make the judgment, to give an assessment, and it is mainly a political question then, yeah, then it is difficult for the court to come to that conclusion, that this is a better decision than that one. The court just can say, the only thing that the court can say is then, yeah, both of them or all the four are optional, are options, and we leave it. And since they are not illegal, they are not unlawful, they do not violate these normative, the substantive and these formal norms, yeah, then we just must accept that it is not unlawful what happened here. Yeah. So even if a decision is being quashed or is being altered by the administrative authority, that can be the case that it is still within the boundaries of the legislation and therefore not unlawful as such. And this is a big issue that quite often decisions that cause harm, that cause damages, might not be unlawful as such because the administrative body has a wide a room for discretion and can make decisions, can balance interests, and therefore, yeah, for you as a victim, yeah, are with empty hands, so to say. Yeah, can you click again? So that is with administrative decisions. So there is a big problem to identify what is exactly unlawful and what is not, because and the problem does not lie in the when it is against the legislation, but the big issue is always within the legislation there is quite of a room to maneuver. Regarding legislation, well, you can think, or I hope that especially the legislator has almost endless discretion. The legislator can make all kinds of decisions it wants, right? Of course, there are some boundaries. There are some boundaries. And when do we come to the conclusion that legislation is unlawful? Well, only if the court concludes that there is unlawful legislation. And then the legislation is considered to be exempted, meaning not applicable in this case, or non-binding. And that means there has to be a thick cross through the legislation. It is seen as unlawful, has to be cancelled, etc. Quite often, and I think you can imagine that the court does not easily come to the conclusion that legislation is non-binding, because then the court pretends that it knows better than the legislator. Quite often, the court was just confined to exempted, meaning in this case, you cannot apply the legislation. And why is that? Well, because you don't want to put yourself above the legislator. That would be very, very difficult in the trias politica, right? So exempted is easier to accept than non-binding, although it sometimes happens that legislation is seen as non-binding. And of course, in the end, it's quite often it's a silly joke, because if you allow exemptions in many cases, it's effectively non-binding, right? So there is, but it's mainly, sometimes it's mainly a theoretical debate that we are having here than a practical debate. But quite often, I interviewed many courts, court decision makers, and they often say, I prefer to have this exempted decision than the non-binding decision. And when is legislation illegal? Well, in the Netherlands, we are part of the European Union, and the European Union is a separate legal order itself, and creates binding rules that has to be implemented by the national states. And that means that sometimes a legislation that is seen as an implementation of this European law, yeah, can violate that European law, can be an incorrect implementation of this European law. And then we have illegal legislation, and that happens. That sometimes happens. Mainly about EU legislation, sometimes also human rights treaties. That can also be a reason to conclude that the legislature is illegal, but mainly EU legislation. Sometimes, but only in rare occasions, you will see that the legislation is against unwritten norms like discrimination. We have legislation that made this distinction between groups based on age. So the older you are, the more rights you get, or the other way around. And that was not, well, within the, let's say, the scope or the aim of the rules, and therefore seen as discriminatory, so unlawful. And sometimes, but in very rare occasions, you will see that the court can come to the conclusion that this decision, this rule, exceeds the proportionality test. And to give you one example, when the court made this decision, that was it was legislation that introduced the so-called alcohol lock. The alcohol lock means if you are caught with drunk driving, so you drink too much and you are still driving a car, and you are caught by the police, you could be subject to the so-called alcohol lock, and that means that you have to install a kind of a device in your car and have to breathe through it, and then the lock would then, well, unlock, and you could drive. and every now and then the luck would ask you to breathe again. And if it then concludes that, yeah, you have too much alcohol in your breath, then it would lock again and you could not drive. So it's a very effective remedy. But there was one big caveat, one big problem, is that you had to pay for this device yourself. And this device would cost you 8,000 euros. And that's, the issue is then, of course, isn't that a little bit too much, given the fact that if you would be caught by the criminal court, you would end up with only 2,200 euros at the max. And that is seen as disproportionate. This decision, this law, this was based on the legislation, was seen as disproportionate. And then the Supreme Court in the end said, I have to annul, so even non-binding, this legislation because it is disproportionate. You did not think through all the consequences of your decision. Yeah. So sometimes it happens, but it's a rare occasion, rarely. And actually what helped here was that it was not formal legislation, not issued by the parliament, but it was substantive legislation based on formal legislation, like delegated rules. It was issued by a ministry. That also makes it a little bit easier to come to this conclusion, but it doesn't happen that often. Yeah, can you click again? And to give you examples of another example of this proportionality and unlawful legislation kind of test, that happened with the lockdowns. The lockdowns were based on rules and regulations, and almost every measure in the lockdown era has been tested by the courts. And you understand perhaps the reasons. It is a big infringement of your personal rights, your freedom rights, your rights to exercise your freedom to open a shop and to earn money. And almost all these decisions have been tested by courts, and quite often using, or actually always using, civil law procedures, trying to force the civil court to say that the decisions, the regulations are illegal because they infringe, they are unlawful because they infringe my personal rights, and therefore are disproportionate, etc. And there was sometimes so the main argument was it is unlawful, it does not have a solid legal base in legislation, and is disproportionate. And actually, all the courts denied these claims. And the big reason is, as always, in a crisis, the discretion for the legislator is almost limitless. I think it's the same in Indonesia. And then because we are in a crisis, we need to do this because otherwise the consequences will be severe, etc., etc. But what you could see is, although the court accepted this huge discretion, it also asked a lot of from the legislators to provide evidence. Why is this lockdown effective? What is actually the consequence of this lockdown for the spread of the disease, etc., etc. And so it was very funny, and so not disproportionate, and therefore not unlawful. Yeah, next one, please. And so that was with so actual acts that has not been seen as unlawful. And perhaps even more interesting case is the agenda case. And I think especially City finds that very interesting, because this was, it was legislation, there is legislation, but Agenda, it's an NGO that wanted to, to force the government to do even more, and the legislator to do even more. And therefore, said to the, issued a tort law procedure, went to the civil court and said, yeah, the state is not upholding its promises, the promises that they agreed upon in international treaties. In international treaties, they promised, the state promised to lower their carbon dioxide emissions. Your current legislation is indeed aiming at lowering, but not enough. And now you have to do something. You have to issue new legislation. You have to make decisions to indeed effectively lower the emissions. And the funny thing is, we all my colleagues and myself as well, we thought the court is never going to accept this, because what you then do as a court is actually ordering the legislator to do certain things. Well, that is pretty difficult in this trias politica atmosphere, you know? You are then putting yourself even above the legislator. Well, that is quite something. But all of a sudden, or actually by surprise, it took us by surprise, the district court, then the Court of Appeal, and in the end, the Supreme Court accepted this plea and is indeed oblige the state to issue rules, regulations, lowering the carbon dioxide emissions, and therefore fighting against this climate change, so to say. And the interesting thing, and why we find it interesting and also problematic, is that here you see that the court is infringing with the political debate, because in the end it's a political debate. There is a political debate between, on the one hand, the climate and the environment, and on the other hand, we must also have some kind of economic development. Everything you do to against these carbon dioxide emissions will harm the economy, right? You have to close down a coal plant or something, and therefore you have to do other things, etc. I think you can imagine that it's a complex situation, and here the court takes a position in a political debate. So therefore, it is pretty something that is happened, so to say. And also very funny, Urgenda did not ask for damages because they did not really have any damages, but they just wanted an order that there has to be new legislation. So it's a very funny, interesting one. And why it is so funny and interesting is that this opened the door for more of these kinds of lawsuits based on tort law, fighting against the legislator in the end, and forcing the court to take a position in this legislative debate. Next one, please. So, when is there illegal behavior? Well, if the administrative decision is quashed by the administrative court, or if the administrative body accepts that it is illegal, or if the legislation is annulled or non-binding or whatever by the civil court. But there was a big problem with the first one, the administrative decisions are annulled, because we have the problem of the formal legality. That means that after 6 weeks, nobody challenges a decision. We take that the decision is legal. And suppose that after the 6 weeks, it turns out to be an illegal decision after all. Then there is an interesting problem in the law, because there isn't something illegal, but it is considered to be legal. And you still have damages. And what then? That's an interesting problem. And I will come to that one here in the mining case, because this happened in the mining case. The mining case, mining is done based on a permit. Permit was issued 20 years ago or even longer by the Minister of Economic Affairs. And by that time, and in the legislation, you're supposed to issue the permit. And if you issue the permit, you're supposed to balance the interests between, on the one hand, economic growth, and we will earn all the money because the mining company has to pay taxes. And well, the government is also part of the mining company. So economic growth, that's one hand. But also, on the other hand, potential damages, potential victims of what you're doing. And the idea is that you're supposed to balance these interests. And it was clear after 20 years when the earthquake arose and when the damages became more clear, it was clear that this decision by that time was perhaps correct, because they didn't know. But now we see it is incorrect, because you did not pay enough attention to the damages of those, the victims of your decision, so to say. And that's an interesting problem, because from a legal perspective, it is still a valid legal decision. But now we conclude that it was a wrong decision after all. And then the Supreme Court came to an interesting solution. It said, well, although the fact that it has legal effect, it is still a legal decision from the legal point of view. That does not form an obstacle for us to say that there is no reason for damages, so to say. And then the damages are not based on illegal behavior, but it's like compensation for legal behavior. That's an interesting variant, so to say. We call it in France, égalité devant la charge publique. That means equality for the public interest. Someone faces trouble because the whole society is, well, benefiting from it, then this someone has to receive compensation. And so, but that's an interesting variant, so to say. So still damages because there was a disproportionate decision after all. Yeah. Okay. So question number one, what are actually the causes of the action or the damages? Question two, when is it illegal? And then question three, but when do you qualify for damages? That's also an interesting problem, because there are always two big issues, and those of you who are familiar with tort law will recognize this. Is there indeed a causal relation between, what we think is the cause, the thing that the government did, and the damages that you face? That's a big one. And the other one is, if there is indeed a causal relation between the two, then the question is always, what you did is apparently illegal, so it violated a norm, but did this norm that has been violated also protect your interest? That is the problem of relativity. Does that ring a bell also in Indonesia, relativity or not? Yeah, no? Well, this is a big issue, relativity and causation. Causation is the first one, causation is actually the problem, is what the government did, indeed, does it have a relation with the damages that you face? Is there indeed a causal relation between the two? And the issue is always that in normal behavior, like factual behavior, the car hits the wall, that's factual behavior, where it's clear that the factual behavior caused the damages because the wall is broken. That's the idea. But with governmental behavior, whether or not that actually caused the damages is not always very clear. Is there indeed a causal relation between what the government did and your damages? That's not always clear. Like the child benefit case. You can say, although you lost your money, you had to go, you went bankrupt, but there might be other reasons why you went bankrupt, right? So it might not be due to the fact that the government reclaimed the money, or the fact that you lost your child, that your child has been removed from your house. That was actually also the case in this child benefit case. Yeah, there can be other reasons why the public authority that is responsible for raising kids had to remove your kid, right? So that's a big issue. And to make it even more complex, this whole causal relationship issue, in the jurisprudence, the court said, it's not only about, let's say, the strict causality between the two, but also we allow that the government can make some mistakes, but as long as it was able, for example, this mining issue, by that time you made the right decision, and only later on it turned out to be the wrong decision. Were you able to make the right decision in the first place? If yes, then there is causal relationship, but if it turned out to be wrong, then there is no causal relationship. That is, we allow a little bit more, let's say, wrongdoing by the government compared to us by ordinary factual behavior. And that's especially the case in this administrative decision and this legislation. We allow the government to make mistakes. Only a few mistakes are allowed. If you were able to make the right decision in the first place, then there might be a causality. But if you were not able, then there is no causal relationship. And you see this even more with lots of the problems arise from procedural problems or delay in the decision-making procedure. These might cause damages. But procedural faults, whether or not that actually make the, suppose again, you are in the situation of asking, applying for a permit to create your own nuclear plant. Who doesn't want that now? I don't, but suppose. You made investments, you made promises, you already signed contracts with the constructor, whatever. And normally the procedure to get a permit is 6 weeks, but you already know that it's not going to happen with such a complex project, right? But you cannot really anticipate on when the government is actually issuing the permit. So when is it then that the government is exceeding its reasonable time frame, so to say, and when is the accession of the time frame? When is that actually causing your damages? That's not an easy to answer question, so to say. Next one, please. Then the relativity. That is the problem of, does the violated rule in norm indeed also protect your interest? That's not always easy to assess, or in other words, it's not always easy to accept. It's easy when it comes to the one that's asking for the permit is denied, and later on the permit is given anyway. Then the violated norm is also protecting your interest. But especially for third parties, suppose I give you a permit and later on it turned out to be wrong, but then was the fact that it was issued in the first place also protecting your interest, is a difficult one. We have an interesting case in the Netherlands. It is we had a mentally disrupted person. He had, yeah, it was not a very clever decision by the municipal, but he got a permit to hold a rifle. And with his rifle, he committed a mass shooting in a shopping mall. It was years ago. And then the victims of this mass shooting, only a few died. So it was not good, but it was not that terrible as I stated. But okay, the victims of this incident took two routes. First of all, they issued a claim against the one that committed this crime, saying you caused damages, etc., etc. Well, that's an easy to win case, right? But yeah, there's one issue. He was not very rich, so you could not get real compensation. And of course, the insurance company would not pay either, so empty pockets. So they also tried to hold the government, the municipality, accountable for issuing this permit. And yeah, then there is an interesting problem. Did the decision to issue this permit also protect you as an outsider? Hey, you are not the one that is asking for the permit. But you are the one that is suffering the consequence from the fact that someone else got the permit. That's not an easy claim, I would think. Eh? But here you saw that the court accepted the claim. And why was that? Because in the decision making, the legislator said to the administrative court, the administrative decision. So in the legislation, it said if you issue a permit for holding a rifle, you have to take into consideration certain interests, like interest of mental capacities, etc., but also the public order. The public order has to be well taken into consideration. And then the court said, the civil court said, because you violated this norm of taking into consideration the public order, that also protect potential victims of those with a rifle. And with that, the government was liable after all. But you can see it's tricky, right? It was something, it was a very, let's say, creative approach, and the court accepted it. So that was funny. Yeah, so, and that's the relativity often regards the third parties, those who do not get the permit or those who are, let's say, surrounding the administrative decision. And then the question is always, is the violated norm also protecting the interest of this third party? And with this rifle case, it has been accepted. Yeah, next one. Okay, so acts. What is the act that caused the damages? When is it unlawful? And what are then the criteria? And then we have seen the problems of causation and relativity. Suppose that we can accept causation and relativity. Then the next question is where? What are the procedures? And there is an interesting development going on in the Netherlands. In the past, the idea was that the administrative court is only there to assess the legality of decisions, and everything that is, well, related to that in the sense of potential damages, etc., you had to go to the ordinary court, we call it. It's actually the civil court. In the Netherlands, we have a formal distinction. Administrative court is responsible for administrative decisions, and everything else you have to go to the civil court. But then there is a different problem, because suppose that there is no decision yet from either the administrative authority or by the administrative court that the decision is unlawful, then the administrative court has to accept that it is seen as legal what happened there. So there is then no basis for damages, right? So there's an interesting problem. And there's only one exception, it's the mining case. So it's lawful, but we consider it unlawful because you did not. But that's a very difficult route, so to say. So what we've done then, the legislator then, actually it started all in jurisprudence. So sometimes the administrative court, even it was not its main task, still accepted claims for compensation as part of the procedure. And that's now being codified in the law. So now you can also go to the administrative court saying this decision is unlawful, and since it's unlawful, I suffer damages and I want compensation for these damages. So we now have two routes to answer the same question of did I get damages and do I need to get compensation for that? So we have two options, either the ordinary court or the administrative court as part of the administrative court procedure. Next one. And then we enter into a new unrouted domain because now you have two captains on the ship. You have two routes answering the same question. You have the administrative court and you have the civil court, and they both are dealing with the same questions. So now, and that's interesting, it's pretty likely that they will come up with different conclusions on the same decisions and of the same questions. Like the problem with the legal effect of the decision. So what is the room still to say that it's illegal afterwards? I mean, you cannot go to the administrative court if the decision has legal effect. Then you must go to the ordinary court. And suppose that the ordinary court then comes to the conclusion, yeah, it was illegal afterwards. That would be very interesting, because then the administrative court, the ordinary court is then saying something that's actually within the jurisdiction of the administrative court. And all the other problems like relativity, causation, it is pretty likely that both the routes come to different conclusions on what is actually causal relation and what is actually relativity, or in which cases, so to say, do we accept relativity, in which cases do we accept causality. And that the consequence can then be that similar questions are treated differently by different courts. And well, that can be two ways. On the one hand, you can be very positive about it because it gives us room to maneuver us as citizens. But on the other hand, it can be also very confusing. And since normally we would say that the administrative court is more accessible because you don't have to pay a high court fee, issues of evidence are treated more easily. But still, yeah, if you got less money over there, yeah, then it will be an interesting inequality, so to say. Yeah, next one. So, and we are now in that deep domain. So, for my future research, or the research of my colleagues, that will be focused on these issues, on how to what are practical solutions, etc. And the funny thing is, and that's actually my research interest is not so much about what the law looks like, but also what solutions do people do in the bureaucracy find. And often you will see that there are practical solutions in the sense of creating new compensation schemes, like the mining situation. Since it's accepted that there is illegal behavior, what you see now is that the legislator issued new rules and regulations, creating a new specific procedure, fast, easy, cheap, to pay for the damages. So a special compensation scheme. And the same goes for the compensation for the child benefit, for example. Once it has been accepted that it was illegal what the government did, the minister had to resign. So it was a serious situation, so to say. The next day, the government created a new compensation scheme, giving all the victims 40,000 euro without questions being asked, so to say. Even if you had less damages, you would receive the 40,000 euro as a first step of the compensation, so to say. And all the other cases, if it was not sufficient, then you were treated with a specific procedure, with a specific committee, etc., etc. That's what you often see, that especially in the, let's say, the bigger, more occurring situations, the legislator or the government will create new rules, new legislation to solve the issue. But it always demands a first step of accepting the fact that what has been done here is unlawful. And I think that was my last slide, but you can to verify. Yes, thank you so much for your attention, and I'm looking forward for your questions or remarks.
Okay. Thank you so much, Professor Albert-Jan Tolenaars. That's such an interesting presentation explanation to us. And for whole your presentation, I can conclude there are two one similarities with the Indonesian situation and one different with the Indonesian situation. I start with the different one. The different is that in the Netherlands, it seems like there are so many areas that can there is a cost that we can sue the government, such as like there is a delaying when the government should suing a decision, suing a permit, but there is exceeding the time frame, for example, so we can shoot the government because of that issue. But in Indonesia, there is no happen like that because yeah, we are, seems like it is obvious, it is a common that the government just delaying their activity, delaying their obligation to our citizens. That's the one point. Even such legislative can be so unlawful action when there is a implementation is not proportionally, for example, or there is a discriminations. But Indonesia, we do not recognize such thing. So I think the Netherlands or the Dutch people very criticize their government from your explanation. But the similar thing is about the two captains in one ship. That's the procedure, right? There is a civil law court and there is an administrative court, and the two of court body have similar authority to conduct or to examine, to assess the government actions. That's very nice. I can conclude that. And your recommendation is clear that we have to change with the administrative court instead of the civil court, right?
Well, that is a solution that we have in the Netherlands because it's seen as more accessible and
Okay.
And also because the administrative court can say something about the legality of the decision. That's more difficult for the ordinary court, the civil court, so to say.
Yes.
But therefore, since there is so big connection between the two, yeah. But there is also a reason to say it's not good because it is pretty likely that you will get less compensation in the administrative court than within the civil court, right?
This happen also in Indonesia right now.
Yeah.
Okay.
Yeah.
Let me conclude first, but I will conclude it in Bahasa Indonesia because the all participant is Indonesia.
Yeah.
So we are more convenience to talk in Bahasa. Baik Bapak Ibu, saya akan menyimpulkan dari tadi yang sudah disampaikan oleh Profesor Albert Tolenar bahwa tort law dalam bahasa Indonesia adalah PMH, perbuatan melawan hukum yang itu dilakukan oleh pemerintah yang saat ini sedang kita diskusikan. Bahwa itu biasanya perbuatan melawan hukum itu dilakukan oleh person gitu atau private entities, tapi ini dilakukan oleh pemerintah. Jadi di situ ada suatu bias ya. Lalu bagaimana ketika itu pemerintah yang melakukan, di mana pemerintah itu juga dia punya kepentingan untuk melindungi public interest gitu. Jadi itu dilemanya di situ. Nah kemudian yang dijelaskan tadi oleh Profesor Tolenar bahwa kalau di Belanda itu apapun itu bisa menjadi bahan untuk menggugat pemerintah gitu. Misalkan ketidakcukupan pemerintah dalam menangani COVID misalkan, kemudian pemerintah menerapkan legislasi yang dia itu sifatnya diskriminatif gitu ya, atau tidak partisipatif gitu. Misalnya kalau kita punya omnibus law, nah itu kalau udah di Belanda udah pasti digugat, itu unlawful, gugatannya pasti melawan hukum gitu. Kemudian juga misalkan tadi disinggung juga Wahenda cases ya, yang dimana itu saya interest di situ juga bahwa legislasi itu pemerintah bisa digugat karena melawan hukum karena menerapkan legislasi yang dianggap kurang cukup, misalkan terkait dengan penanganan perubahan iklim yang harusnya pemerintah itu punya standar yang lebih tinggi gitu ya untuk mengetatkan pencemaran udara, tetapi karena tidak maka pemerintah dianggap melawan hukum, dan itu pengadilan itu bisa memerintahkan pemerintah untuk merubah kebijakannya gitu dan dinyatakan melawan hukum, dan supaya kebijakannya dirubah supaya lebih bagus gitu. Dan kemudian misalkan juga yang ini tadi yang saya sampaikan bahwa kita punya satu persamaan dan satu perbedaan. Satu perbedaannya tadi apapun itu bisa menjadi dasar gugatan, seperti exceeding the time frame, misalkan keluar dari jangka waktu dalam pengeluaran izin, misalkan izinnya itu 1 bulan itu udah jadi atau 1 minggu udah jadi, tapi kok ini enggak, delaying. Nah itu bisa juga menjadi gugatan karena di situ ada hak yang dirugikan misalkan. Dan contoh soal lockdown, misalkan pada saat COVID lockdown itu juga kalau tidak proportionally, pemerintah itu mengeluarkan kebijakan lockdown itu tidak proportionally, itu bisa menjadi juga gugatan melawan hukum. Kenapa? Karena di situ ada kepentingan gitu ya, ada kepentingan misalkan orang punya kafe terus dia jadi nggak buka, kemudian orang nggak bisa exercise, nggak bisa olahraga, jadi kepentingannya itu terdampak karena kebijakan lockdown. Nah itu bisa kalau tidak proporsional atau tidak tidak seimbang, itu maka bisa menjadi bahan gugatan. Dan tentu yang mengassess atau menilai bahwa apakah pemerintah itu melawan hukum atau enggak itu adalah pengadilan. Maka pengadilan itu tadi ada doctrine of relativity dan juga relativity, kemudian causal relationship, right? Causal relationship. Jadi apakah ada hubungan sebab akibat gitu atas kerugian dengan tindakan pemerintah yang digugat itu, atau causal itu hubungan sebab akibat kita juga punya ya gitu, bahwa dalam membuktikan seseorang itu bersalah, apalagi untuk meminta kompensasi atau damages, itu harus dibuktikan causal relationship-nya. Atau kemudian relativity ya, relativity itu terkait ya kalau pemerintah itu hanya bisa digugat dan dipersalahkan kalau tindakannya itu secara melanggar norma yang ditujukan untuk melindungi hak seseorang. Jadi kalau norma itu dilanggar, maka pemerintah bisa dinyatakan bersalah. Tapi kalau itu nggak terbukti di pengadilan, maka ya itu no liability, maka pemerintah tidak bisa dianggap bertanggung jawab. Dan itu sebenarnya mirip gitu ya dengan Indonesia. Nah, kalau persamaannya, kita punya sama-sama kebingungan bahwa di situ gugatan terhadap pemerintah itu bisa dilakukan di pengadilan negeri, di civil court, dan juga di administrative court atau di PT UN. Jadi tadi yang dikatakan two captains in a ship gitu ya. Jadi ada 2 kapten di dalam satu kapal. Nah itu di Belanda juga terjadi seperti itu gitu ternyata. Nah kemudian Prof. Albertjan menyarankan supaya kita lebih menitik beratkan bagaimana kalau memang diarahkannya ke administrative court saja, karena di situ adalah memang pengadilan yang untuk mengadili tindakan-tindakan pemerintah. Nah itu tadi mungkin kesimpulan besarnya seperti itu. Okay, we get into the Q&A session. Okay, for those of you who want to ask the questions to Professor Albertjan, please up your hand. And for those of you who want to deliver your question in Bahasa Indonesia, please do not hesitate to do so. And I'm here to help you to translate it for Professor Tolenar. Okay, well done.
Dank je wel voor het tijd en leuk met je te ontmoeten. Als ik mag je vertellen, vroeger ik woon in Nederland voor 8 jaar, maar het is 10 jaar geleden dat ik heb niet mijn Nederlands gebruikt. Zo voorgeven als mijn Nederland is niet zo goed als vroeger. But I'm still going to deliver my question in English. So my question is, if I'm being positioned in working in the government and I see someone with a higher rank than me, does the tort law individually that you mentioned before that that is the sector in private law, but what should I do if I'm being the witness? And because me with the lower rank can be afraid to be fired, for example, or as we know, this kind of position is not only the problem in administrative law, but also maybe in the police, that if we see someone with a higher rank does the violation, then we are afraid to report it. Or should I place myself as a whistleblower so my name could be anonymed? Thank you.
Maybe you want to answer directly, or we collect 1 or 2 more questions.
I would want to answer immediately because I don't have a notepad, okay. Otherwise I'd forget it.
Okay.
It's a very good question. It is like the difference, let's say, between personal accountability, personal liability, and state liability, so to say. And your idea is that as an individual, you play also a role in the end, and you should perhaps report it or try to prevent this illegal activity from happening. That's what you say. Let me say first one thing. In this child benefit scheme, there was also individual civil servants were held liable, not in civil court, but by the criminal court. So they were doing things that were seen as illegal and were therefore prosecuted. In the end, it did not turn out to be a case, but still. So it can happen that individuals in the system are held accountable. But for the civil court accountability, it is never your individual responsibility for the things that happened. You do this because you are exercising a public power, and therefore the government, the agency, or the ministry is accountable. And your question is now, what should I, as an individual public servant, then do? Yeah, you should try to prevent this from happening. You could report this. I would always report, in the sense, make sure that you have notes, because that also accepted your personal, feeling, I would say. And whistleblowing is, of course, one issue, but I can imagine that's sometimes difficult to realize that whistleblowing is always problematic. Also in the Netherlands, it's always problematic to become the whistleblower and still to have your position protected without getting fired, right? But in general, this whole issue of personal vis-a-vis the organizational issue is not really a problem in the civil tort procedures. it can be a problem in the penal accountability. Does that answer your question? By the way, your Dutch was perfect. I could understand it.
Dank je wel.
Ah, I see.
Okay, maybe there are another participants would like to questions. Okay, Mas, silahkan.
Professor Albertjan, I would like to ask some questions. But before pardon me, I want to introduce myself. My name is Muhammad Ali Hussein Mubarak. I'm a student of Magister of Law in UAE. I would like to ask some questions. How about green constitutions, sir? Do green constitutions really need in order to support tort in order to prevent tort in administrative law, especially in to prevent environmental damages, and how the implementation in Dutch? Do Dutch today already implement green constitutions? Thank you, sir.
Can you repeat your question? Because I did not really get it. What is it? Does the Constitution recognize tort law? That's what you asked, right?
I would like to ask you about a green constitution, sir. I just wondering, sir, do green constitutions really need in order to prevent tort in administrative law, especially to prevent environmental damages? And how in Dutch do Dutch today already implement green constitution? Thank you, sir.
Okay. Well, okay, I think I understand your question. The issue is that the Constitution as such does not prescribe the fact that there are tort law procedures and that you can use it. There is only one thing, Article 6 of the European Convention of Human Rights. That's like you have the Dutch Constitution, but you have the European Convention for Human Rights that we are adhering to, that says that everyone is entitled to go to court to claim his or her rights. I put it a little bit in layman's terms, so to say. And that means that if the court or if the state does something that is affecting your personal rights, you must be able to go to court against that, so to say. And that means that you can go to court against a decision, to the administrative court, but also there must be a procedure to get your damages. And therefore, we used to have this situation, well, the legality of the administrative decision, you go to the administrative court, and when it comes to getting damages, you have to go to the ordinary court. And that you could say is an implementation of this fundamental principle of Article 6 ECHR, saying there has to be a court answering to your claims on your personal rights, so to say. Yeah, so it's not written down in the Constitution, but there is a trace in the European Convention of Human Rights that more or less, forbids the states to disallow you to do this, so to say. Yeah, double denial. That's what we like. You understand? Yeah, there must be a procedure to get your claims. Yeah. Does this answer your question?
Okay, sir. Thank you.
Yeah. And regarding your last question, does the students work on this? That's what your question, right?
Yeah, sir.
Yeah. There are PhD students, if that's your question, who are assessing this, both on the perspective of legal structures. Does it fit? The whole idea of the two captains in a ship. What is actually the normative framework in which you function? And does it fit? Does it align with the normative framework in which the administrative court functions? That's a normative question. But also more empirically, what does it mean if to go to the administrative court? What can you get there? Does it? I mean, it is pretty strange to already preclude in your claiming procedure that the decision is unlawful. Normally, it's a two-phase procedure. First, you say the decision is unlawful, and then I will face you to get my compensation. But now you have to do both in one procedure. That's perhaps strange and perhaps difficult. So these are also interesting research questions. Yeah.
Just to answer your question,
Yeah, Bu.
Okay. Okay, maybe the other participants. You can deliver your question in bahasa, don't worry. Boleh pakai bahasa Indonesia. Any questions? No questions? Oke, silahkan Mas.
Check. Okay, thank you, Mr. Professor Albert. That was an interesting topic. And before that, let me introduce myself. My name Aufa Muzaki, and I'm a postgraduate student in Master of Law program UII. And my question is, in your presentation, you mentioned before that there is two options to quash the government decision. We can sue the government in a civil court, and also we can sue the government in administrative court. Okay. And what if there is one similar cases, like a lockdown decision, two different courts? I mean, we sue the government in civil court, and also we can sue government in administrative court. I think that's all. Thank you.
Yeah, it's a very good question. I think I did not make myself clear enough then. The decision or the procedure to get a court decision on the unlawfulness of the decision, administrative decision, has to be done by the administrative court. That is his or that institutional prerogative. So we have the situation that you could say, under Article 6, you have to go to court. You have to be able to go to court. Article 6, European Convention on Human Rights. And then in the Netherlands, we say against administrative court decisions, you have to go to the administrative court. But now there is, perhaps that's what you are referring to, there can be the situation that the administrative court procedure is not available anymore because you exceeded the time frame. You have to appeal within 6 weeks, for example. And if you exceed the time, then it's considered to be lawful, whereas it might have been unlawful if you would have been able to go to court within the 6 weeks, right? That can happen. And then the interesting point arises what you say. Then the civil court has to accept the legality of the decision of the administration, but still, under the mining case, Supreme Court ruling, that does not prevent us, the court, from saying that there are damages that have to be compensated. Yeah, but then there is the theoretical starting point is that we consider it to be lawful because there is no procedure anymore to say it's unlawful. You understand this? Yeah. So it's not the fact that you can go to two courts to have a claim on the unlawfulness of a decision, but what is true is that you can go to two procedures to get compensation after. Yeah.
Thank you for the answer. Maybe the other participant would like to ask the questions. Ada yang mau bertanya? Boleh, silahkan. No more? Okay, Bu Ayunita. This is one of my colleagues.
Good morning, Professor Tolenar. My name is Ayunita. In Faculty of Law, I teach about labor law. So my question, I think out of context, but I'm curious about your explanation about the differences between the public law and private law. So in your country, you say that this is a strict boundary between the public law and private law. So in Indonesia, we have some measure of law that the position of this law between the public and private law. For the example, labor law. The position of labor law, this is between the public law and private law. I said that this is between the public law and private law because in labor law we have individual work agreement. This is between the worker and the employer, and but some intervention from the government. So this is the public law. So my question is, in Netherlands, how about the position of labor law? Is it in public law area or in private law area? Because this is related to the dispute resolution, how to resolve the problem about the public law case. Thank you so much.
Yeah, it's a very good question. And by the way, it's also very nice that you reacted on my first slide of Ubianus, saying there's a strict boundary between the two. And I hope to make clear that although we started off with there is a strict boundary, in reality, there is not such a strict boundary. There is public, there is private, and there is something in between. A very gray area, blurry, sometimes a little bit more private, a little bit more public. You see this now with this compensation scheme under the administrative court law. The administrative court is now applying civil court rules. So that is really something that is halfway, right? And your more specific question on what about these public servants? Are they seen as, especially the relation between the employee and the employer, is it then part of administrative law or is it part of civil law, labor law? In the Netherlands, it used to be part of administrative court law, but it changed a few years ago. Now it's considered to be ordinary labor law. The same debate as you mentioned here, we had that why are civil servants special compared to ordinary employees? That was the idea. It was very funny, by the way, because I was also a member of objection committees of public administrations, and you can imagine that that sometimes there was a case about a civil servant being fired or whatever. And then we then had to apply administrative law rules, so to say. And although at first hand you would think that civil servant is protected better, because there was not easy to get rid of someone, and that's you can think of all the reasons like whistleblowing. They must be protected better than normal employees. That's the idea. But in other situations, the civil servant was worse off, especially when it came to compensation. If you got rid of someone, you had to pay some extra money to get it done, so to say. But under civil law, there are more compensation schemes under labor law than under original administrative law. And now it is all one scheme in the Netherlands, and you have to go to the ordinary court if you want to get rid, or if you want to have a disciplinary action or whatever against your civil servant. Is this your field of expertise?
Thank you. Thank you, sir.
It's interesting. Labor law is, I can get you in touch with people in the Netherlands, perhaps to know a little bit more about, because this debate is going on for years in the Netherlands, and now they made the decision. The legislature made the decision to treat the civil servants as ordinary employees, applying ordinary labor law, but still, whether or not it changes something in reality, I don't know. It is, it's very interesting.
Thank you, sir.
Yeah, I hope that's address your question. Another participants, maybe we have still, it's enough sufficient time to discuss further. Any other? No other? Okay, if there is no questions from the participants, we can close today, Mbak Nisa, for the master ceremony. Okay, thank you very much for Professor Albert Tolenar. Yeah, thank you so much. Please give the applause once more for Professor Albert Tolenar.
Okay, thank you to Professor Arbjan Tolenar for the insight given for us here. And also thank you for Mrs. Siti Rohamama Datila SHMH as the facilitator for today's agenda. Okay, ladies and gentlemen, actually the next session is reward souvenirs that it will be given by Pak Idul. He was going here. We will invite Dr. Idurisan SH LLM to give the souvenir, and also we also invite Professor Albertan Tolenar for receive a souvenir from Faculty of Law, Universitas Islam Indonesia. Please. Okay, this one is session of giving souvenir from Faculty of Law, Universitas Islam Indonesia, given by Dr. Idurisan SHLM, received by Professor Albertan Tolenar. Please. Okay, give applause. Thank you very much. You may cordially take your seat. Yeah, ladies and gentlemen, finally we come to the last agenda. Is also a closing. So let us close this agenda. Public lecturer visiting Professor Chot Law in Administrative Law, the Dutch perspective, held by Magister and Doctoral Program Faculty of Law Universitas Islam Indonesia by reading Hamdalah together. Alhamdulillah. Thank you for the attention. Billahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh. Yes, thank you very much.